Before Insolvency and Bankruptcy Code 2016, the insolvency and bankruptcy laws in India were multi-layered and fragmented. IBC created umbrella legislation for insolvency resolution of all entities in India, both corporate and individuals. IBC's journey so far has been a mixed bag. In the last 2 years, the debt resolution of SIC companies slowed down considerably after initial euphoria saw several successful acquisitions by top companies, including the Tatas, Reliance, and the world's largest steelmaker, ArcelorMittal. The problems include a very high haircut, as much as 95% in some cases for banks, and delays in the resolution process. The provisions of the code that came into effect in December 2016 aim to serve two purposes: to save businesses that are viable and facilitate the exit of those that are not. Since then, as many as 5,258 insolvency cases have been filed by lenders. Of these, 3,403 cases have been closed until March this year. Of the 3,406 resolved cases, nearly 47% of companies were liquidated and 17% were withdrawn after 90% of lenders agreed following an offer made by the promoter. Around 22% of the cases are still ongoing, while in 14% of the cases the resolution plan has been approved. Apart from overburdened courts, a serious problem faced by lenders was that asset reconstruction companies are not allowed by the RBI to bid for bankrupt companies. Legal experts say that frivolous challenges and interference by erstwhile promoters, directly or indirectly, to delay the resolution process must not be entertained. The IBC prescribes a time limit of 180 days for resolution, extendable by another 90 days. However, an outer limit of 330 days has also been prescribed for the completion of the resolution process, including the time taken for litigation. The 480 cases which yielded resolution plans took on average 450 days for the conclusion of the process. And of the ongoing cases, 66% have been pending for more than 270 days. But the IBC's track record has been better than the earlier laws. The realizable value of the assets available with the 480 companies rescued was only 1.31 trillion rupees, though they owed 7.61 trillion rupees to the creditors. The resolution plans realized 2.34 trillion rupees, which is around 178% of the liquidation value of the corporate debtors. Financial creditors recovered 32.89% of their claims, which only reflects the extent of value erosion by the time the companies entered the insolvency process. Yet it is the highest among all options available to creditors for recovery.
Although the code was enacted with the primary aim to deal with corporate insolvency instances timely, but in practical sense, none of this is being practiced. To state an instance, the insolvency proceedings of JP Infrastructure took 5 years to conclude as opposed to the period of 330 days. So there are no regulations to govern the non-performance of the officials appointed under the provisions of the CIRP. And more often so it happens that these officials are replaced with the new ones and the entire process stands still till such appointment. It is true that IBC requires some alterations, but what is even more necessary is some objectivity while dealing with the creditor claims. So clearly the limitation period stipulated has been blatantly ignored, but there are some other factors like time and the quantum of claims and the receipt of sound resolution plans that necessitate moratoriums by the tribunal. So lastly, even if the case reaches a decision, recovery of the financial debt is a major grey area left out of the scope of IBC. So the principal debtor, the creditors as well as the tribunals are all affected by these issues due to the paucity of time and resources invested, which makes it even more urgent, which makes it more important for urgent recourse. So some changes, like all players should commit to timely revival process and strengthen the RP system, and also onboard the judges in case of pendency and vacancies in the tribunals. And lenders are also reluctant to participate as it involves in the CRP, as it involves the huge payments to IRPs and they see no light of the day, which is also concerning. So in my opinion, these should be there should be some capping of on the fees of the IRPs, lawyers, valuers and other professionals who participate in the entire process of CRP. And another thing, I feel that the professionals are not experienced enough when it comes to reviving the operations of the company or dealing with the operations of the company. Though they take the charge, but they fail to revive the company.
June 13th marked the completion of 5 years since the RBI identified 12 highly stressed debtors for insolvency resolution under the IBC. These 12 accounts were popularly referred to as the Dirty Dozen. They had an aggregate outstanding claim of 3.45 trillion rupees as against a liquidation value of 73,220 crore rupees. Out of these, the resolution plan has been approved for 8. 2 are still undergoing insolvency proceedings and liquidation has been ordered in the case of the other 2. The recovery ranged from 115% to 387% of the liquidation value for the 8 cases that were rescued through resolution plans. Bhushan Steel's resolution was done and dusted in under 300 days. SR Steels took a grueling 865 days because of litigation. Meanwhile, the lofty haircut taken by banks in several cases like Siva Industries and Videocon Industries came up for criticism by the lower courts. The Supreme Court made it clear that if lenders, in their commercial wisdom, think the offer is good for all stakeholders, then the NCLT and the NCLAT must not interfere. Courts have played a pivotal role in modeling the IBC and paved the way for evolving jurisprudence. As the insolvency law matures, one can expect the average time for a resolution to shorten. One should judge the success of IBC not just from the point of view of recovery percentage. There are other parameters to judge its success too. As a key economic reform, it shifted the balance of power from borrowers to creditors and instilled a significantly increased sense of credit discipline among debtors.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.
क्या हाल?
मत पूछ यार, फिर से स्टॉक्स में फंस गया।
तो स्टॉक्स के साथ बॉन्ड्स, इंश्योरेंस, गोल्ड में बैलेंस कर।
इसमें बहुत तामझाम है।
तुझे 5 पैसा नहीं पता?
अब तो सबको पता है। 5 पैसा है ऑल इन वन अकाउंट। डाउनलोड 5 पैसा नाउ।
अब तो सबको पता है. Investing made easy and rewarding with 5 Paisa. Investments in securities market are subject to market risks. Read all the related documents carefully before investing.